Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you have a great day. For today's story, we will be discussing the recent controversy culminating in now a lawsuit as we look to the issue of Mizkif versus Asmongold and Emiru. So some background is warranted. Emiru is a female streamer. Recently, there was a convention, TwitchCon, and she went to this convention to do a meet and greet, as one might do. A person came up to her and hugged her after having bypassed the standard queue and without permission and just basically assaulted her in the proper legal sense. So this random guy just comes through, bypasses the line, bypasses all security to the extent it existed, and comes up and hugs her and touches her, which is inappropriate unto itself. And then, of course, depending on exactly what the touching comprises, could comprise more serious assaults. But in any event, she was touched in a way that was unwelcomed, and that was a whole thing that we discussed recently. As sort of, I suppose, a follow-on or related story in some ways, Emiru went on a little bit later and did a video in some length describing issues she had in a prior relationship with Mizkif. I say that they're related in so much as it seems that the one sort of prompted the other, because she was touched in a way that was unwelcome and in such a public way, it seemed to inspire her to tell this story because it was in her mind a related experience. You know, one is a fan abusing her, and the other is apparently this former streamer allegedly abusing, or current streamer apparently abusing her. And so she felt a desire to tell people about this past relationship and its many downfalls, about how it went and how she felt it was controlling or potentially abusive. Asmongold went on stream, as he does, to publicly back Emiru on this whole thing and, you know, offer her support. And now this is culminated in basically a defamation lawsuit. So Mizkif is now suing his former paramour as well as the supporter, basically for defamation in Texas. And I suppose we'll cover that for as long as it goes, because that might be interesting. All right, so let's go ahead and discuss this lawsuit on its own terms, such as it is. We are in the Western District of Court we're in the United States District Court for the Western District of Texas in Austin, a city in which I lived for several years, and not that far from my current home of Houston, a city I know well. In the case of Mizkif versus Emiru and Asmongold, as well as One True King, which is a company that Asmongold runs that does sponsorship of streamers, among other things, and gaming related content. So let's read this original complaint for all of its glory and see what it has to say in this thing. Okay, so we've got Mizkif and Mizkif Enterprises complains of Emiru, Asmongold, OTK, and King Gaming, and respectfully wants to show the following. Matthew is a natural person resident of Los Angeles. Mizkif is an LLC. Ronaldo is a sole member. Accordingly, Mizkif Enterprises is a citizen of California. That sounds right. So that's true. OTK is a Delaware corporation with its principal place of business in Austin. Accordingly, OTK is a citizen of Delaware and Texas for the purposes of diversity. That's correct. OTK may be served with process for agents of service. I'm not quite sure why we're, necessarily putting that in the filing, but, okay. Mythic is a Delaware corporation with its principal place of business in Texas. Accordingly, is a citizen of Texas and Delaware. For the purposes of diversity, jurisdiction may be served through its registered agent. King is Delaware Corporation with the principal place of business in Texas. Schnuck is a natural person resident of Texas. Hoyt is a natural person resident of Texas. The court has jurisdiction because there's complete diversity. There sure is. And the amount of controversy exceeds $75,000. Yeah, sure. And venue is proper because at least one person lives here. Yeah, I don't have any immediate problem with that. No immediate red flags, right? Diversity jurisdiction, we want to sue people over a standard lawsuit as long as everyone on the one side of the V is different from everyone on the other side of the V in terms of states, then fine, right? So we've got California versus Delaware and Texas. So yeah, that's diversity, no problem. So that sounds fine. And at least one person lives here. That sounds fine. And also the statements, at least by Asmongold, were made from his home in Austin, which would also, to the extent that they're tortious, give locality for that because the tort occurred there. Although then you could debate about whether they occurred in California or not, but let's go with they occurred in Texas for the moment. So it sounds right on his face. All right. For the past decade, Mizkif has been working tirelessly to build a career in the demanding live streaming and content creation field, primarily on YouTube, a video sharing platform, and Twitch, a live streaming platform. Throughout the years, Mizkif has built his online presence under the handle Mizkif, leading to a multi-million follower presence across various social media. Mizkif's entire professional life has, during all relevant times, centered around streaming. Fine. Mizkif became one of the most successful creators on Twitch with a following of 2.2 million views. He's known for collaborating with other streamers, playing video games, and discussing issues with his followers and subscribers. In 2021, he won a Best Just Chatting Streamer in Streamers. Never hurts to fluff yourself a little bit. You don't want to overdo it, but, why not throw that in there? Sure. The community that Mizkif developed, along with its industry connections and other streamers, his personal reputation, and his business goodwill, allowed him to develop successful business with mobile income streams from streamers, subscribers, ad placements, and more. In 2020, along with other high-profile streamers, Mizkif founded OTK and incorporated OTK, which he remains a part owner of this day. So he's suing himself. Okay, if he's a part, okay, that could get interesting. Defendant Schnook joined OTK ownership in 2020 too. Okay. Through the acts and admissions described below, defendants Schnook, Hoyt, and OTK have, acting in concert, wrongfully and basefully accused Ronaldo of serious criminal activity for no purpose other than to harm him, his reputation, his business, and wrest from him control the companies he helped build. Okay. All right. Mizkif and Emiru began dating in 2022. It's Emiru. Their relationship was not easy on either side. They would routinely face harassment from Schnook's followers, some of whom were stalking Schnook. They got into arguments regularly, and Emiru threatened to kill herself in many of these arguments. Emiru would dress and behave ways that Mizkif thought made her unsafe in life of ongoing stalkers from some of her followers. Ooh, I don't know that I would have said that, man, in your complaint. I don't know. That's like shaming her for the way she's dressing. Yeah, that's not great. I would have kept it more generic. I would have said she engaged in behavior that seemed risky given this. I wouldn't have said the way she dressed, because that sounds suspiciously like you're saying that she's asking for it. So you needed to, that was a bad move, man. You shouldn't have phrased it that way. Yeah. You could have said something more generic and more, if you were writing this, you would have said something more like Emiru engaged in reckless behavior that put her at risk that concerned Mizkif. Something like that. You don't want to say because of her clothes, though, she was asking for it. Yeah, that was a bad call. Shouldn't have phrased it that way. Bad move. At the end of their relationship, Emiru expressed desire to marry Mizkif and raise children within the next 5 years. Okay. Mizkif, contemplating the tumultuous nature of the relationship, could not agree to do so. He called off the relationship and moved from Austin to LA in January 2025. Okie doke. 10 months later, on October 24th, 2025, Schnook hosted a live stream on Twitch. On the live stream, she She's going to kill me for getting her name wrong. I'm really sorry, Emiru or Emiru. First of all, I'm sorry for getting your streamer name wrong. Second of all, I'm sorry for getting your proper name wrong. I promise if you hire me, I will get it right. That will be the first thing I will learn. I'm available for Asmon or Emiru. They both live in Austin. It's just down the street from me, no problem. That's great. I could represent them both. That'd be good. Their interests are aligned. Let's see, where were we? On the live stream, she lied and baselessly accused Emiru of psychological and domestic abuse, stalking and harassment, sexual assault, and threats of blackmail. Okay? These slanderous allegations were made live before an audience of tens of thousands and since been viewed millions of times by various platforms. Okay. In the saved live stream, Emiru gives accounts of their relationship that clearly do not support the allegations she levied. Well, I mean, relationships are complicated, you know. There could be multiple things. Like, relationships aren't necessarily all good or all bad or all evil or all whatever. And to the extent they're abusive, they're not necessarily always abusive at every single moment. There can be moments that are not abusive. In fact, that is often part of the control from more nefarious abusers, that they will, you know, become sweet and kind and caring and loving and all the rest of it. That can be part of the pattern of abuse in some situations. So, yeah, that can, all right. In the same live stream, Emiru gives accounts of their relationship. He's going to burn funds like crazy and not go anywhere. Well, they're all rich. They're all incredibly rich. So if they want to have a fight in court, they all have the money to sustain it. So if they want to light money on fire, I guess, yeah. In the same live stream, Emiru gives accounts of the relationship that did not support the allegations. For example, in her own description of the purported sexual assault, Emiru states that she and Mizkif were kissing, tried to initiate intercourse. She made clear she didn't want to, and he stopped, respecting the line that she'd drawn. So, and saying, quotes, apparently, he started kissing me in my face, and I let him do it, and then suddenly he tried to climb on top of me and aggressively shoved his hands down my pants, and I screamed. And when I screamed, he jumped off like a cat. Well, again, like, this is not, I mean, without even watching the underlying video, right? Without even watching what she said, that could all be true and doesn't also mean that he didn't abuse her at other times. It doesn't mean that he did, but it also doesn't mean that he didn't, right? Because yes, there might have been an occasion when he tried to become sexual with her and she didn't want to and he stopped. That doesn't necessarily mean there weren't other times in which that didn't occur, or there weren't other aspects of the relationship that weren't abusive. So they don't necessarily contradict each other. But, okay. Nonetheless, she continued to defame him and portray him as a perpetrator of sexual assault in a video she knew full well would be viewed by millions. That very same day, OTK sent him a letter purporting to terminate his interest in the company. OTK claimed he was entitled to do so based on the nature of the allegations. Emiru is the handle on which she operates. Well, as to whether or not OTK can terminate their business relationship with him or not would be a feature of principally contract law in this situation, and also their own business practices and their own business and corporation documents. So whether or not they can terminate him depends on the nature of the corporate relationship and the agreements that they have. So I don't know whether or not they can fire him, get rid of him, or do anything else. I don't know. It's like, in order to figure that out, we're going to have to go read some corporate documents. Exciting and fun. Lots and lots of corporate documents. Okay, this letter asserted a number of purported breaches of the owner's agreement. That would be a contract, for example. No such breaches occurred. Nonetheless, OTK asserted it was reclaiming their shares without payment. Okay, so they're trying to take away his ownership interest in the company without paying him. Yeah, that's gonna be a lawsuit. This is not ending quietly, guys. There's no way. This lawsuit might mature into something else. This lawsuit could mature into just a straight business dispute or straight issue relating to corporate stuff. I was dealing on a case on this recently. I am working on a case. I can't talk about it for obvious reasons because it's not public yet, but I'm working on a case relating to a guy who is or was a major corporate leader in a major corporation and was fired and is out millions and millions of dollars. And as you might anticipate, this requires looking through a whole host of agreements. They have arguments, we have arguments, so forth and so on. But yeah, neither their case nor this case is likely to settle easily, because in my case, it's millions of dollars, and this case could probably be millions of dollars. So it's probably going to go for a while. Yeah, although it is a little weird to combine those causes of action into one thing. That could be a whole thing, because you want to sue the company for two pretty disparate causes of action. You can do that. It's a little weird because it's going to get really complicated and really weird, because you have this simultaneous defamation case and also this simultaneous corporate, coup takeover shares kind of case. These are not really very related fact patterns. These are disparate things. So, I mean, the one company purportedly did both. So you can sue them for both torts. It's going to be weird. It's going to be weird doing with it. It's going to potentially lead to weird complications in the lawsuit, depending on how it matures. I mean, obviously, this is just the complaint. This could go in a lot of different directions. But depending on how this matures, this could wind up in some really weird pleadings. This could wind up in like bifurcated pleadings, where one pleading is going to be on one thing and one pleading is on another thing. Could relate to cases being split or merged. It could get really weird. So it's going to be a lot to keep in place potentially. So it could be interesting. The letter further asserts Mizkif owes $600,000 in management fees. Yeah, this lawsuit's going to go on for a while, relating to purported breaches that did not occur. Through OTK, Mythic demanded repayment of these allegedly owed fees. Further, the letter falsely asserted that Mizkif violated his agreement with King, purporting to reclaim his shares in Sting and demanding payment of about $300,000. Yeah. I'm already running this in the back of my head. This lawsuit. I'm contemplating what this will look like. We've got multiple different companies with disparate relationships with each other acting. And when you have multiple different companies, that means multiple different agreements with interactions. You got basically your fundamental cause of action here is a fundamentally breach of contract. Then you've got potentially tortious interference. Then you've got some potential corporate malfeasance stuff that you could do. So because he's a stockholder, that could lead to some sort of actions relating to that based on the stock price or lack thereof. Like the company took actions that were adverse to the stock. So you got some stock causes of action in there. Of course, you've got the defamation stuff. This could get really squirrely. Mizkif, King, and OTK made no serious investigation or inquiry into this. And also for what it's worth, you've got issues relating to what laws are going to apply relating to some of these contracts, because you've got companies with a place of business in one place and incorporated in another place. Now, hopefully their contracts have choice of law provisions in it, which will help to make that easier. Although even then you can get into fights about what law applies, even with choice of law provisions. So we could very easily wind up in Texas court, potentially with Delaware law issues, because these are potentially Delaware corporations with potentially Delaware-based contracts. And so this could wind up, we could wind up bringing some Delaware law into this Texas thing too. Yeah. Yeah. And also, there could be a venue fight also over the issue of whether or not the corporate stuff relating to the ownership of the shares, whether that's in Texas or not. Because if the company and its shares are in Delaware, which presumably is the case, then for issues relating to corporate governance and corporate action, we may be filing in Delaware rather than Texas. So portions of this lawsuit, there could be fights over venue, if for no other reason than convenience of the parties, right? So you could make a credible argument that some of this or all this belongs in Delaware. So that could be a fight for a while. So we're going to fight over which portions of this remain in Texas. That could be fun. Yep. I'm already calculating the billable hours in my head. It's going to get expensive. It could get very, very expensive very quickly. Mythic, King, and OTK made no serious investigation or inquiry into the basis for truth of the allegations before repudiating their agreements. Indeed, Mythic, King, and OTK did not even ask for comment or any investigation in its possession disproving the allegations. Instead, a few days after the defamatory live stream, OTK, perpetuating the defamation, put out a statement on X that fully supports its co-owner and sister, Emiru, and stands by her side and admires the strength. Oh, they're all co-owners. Oh my God. So Emiru is also a co-owner in this thing? Oh, that's great. So Emiru is a co-owner, Mizkif is a co-owner, Asmongold is a co-owner. So it's basically everyone's, the company is now assuming itself. Yeah. This, yeah. Yeah. I'm happy to take this case. If I do, I'm going to need to rent an office for if no other reason than I'm going to need space to store the files because I'm going to need room. This case is going to involve lots of discovery. There's going to be many, many documents. I'm going to need to rent an office somewhere so I can store the boxes. Yeah. In this statement, OTK falsely claimed it terminated its relationship with Mizkif some time ago for reasons unrelated to the recent events. Yeah, that's going to be fun. So when did they terminate him? For what? And so forth. Yeah. Yeah, yeah. Asmongold, who streams under the handle Asmongold, is a part owner of OTK. Of course it is. Since Emiru's live stream, Asmongold has continuously defamed Mizkif on nearly daily basis. He's claimed, among other things, Mizkif should be in jail, claiming he was abusing and manipulating others, hurting people, and becoming an aggressor. Well, should be in jail is just an opinion. Abusing and manipulating others, in what way? Hurting other people and becoming an aggressor. Yeah, are those just opinions or are those facts? That could be fun. Like, are those statements of opinion or statement of facts? Good. Of course, also, we're in Texas, although we're in federal court in Texas. So, yeah, I was about to say we're in Texas, which means we can do an anti-slap, except we can't because Texas has a great anti-slap law. Unfortunately, the Fifth Circuit has already ruled that you can't use Texas's anti-slap law in federal court. So I was like, oh, this is okay. We're just going to use the anti-slap law in Texas. And then I'm like, no, we're not. Yeah. No, not so much. Yeah. That's unfortunate. For example, in a live stream that's since been uploaded to YouTube where it's garnered 1.9 million views as the day of this filing, Asmongold states directly that Mizkif was the aggressor and abuser in relationship with Emiru. This is the weirdest love triangle. Yeah. Asmongold would then qualify his statement by saying at least allegedly, but disclaim the disclaimer itself by saying he has to say it for legal reasons. Okay. Asmongold has on a nearly daily basis reaffirmed the truth of these allegations before his millions of followers. Asmongold has also claimed on live stream there was another, again unspecified, act of misconduct that was the reason that he was removed, which may be true and maybe shouldn't be said. And yeah, and then like, so if there are multiple different reasons they fired him, which reason do they are any of the reasons illegitimate, or any of the reasons legitimate? This, yeah, we're not going anywhere for a while. This is in direct contrast to OTK's own account as provided by its letter. Well, not necessarily. The letter doesn't necessarily itself need to be everything unto itself either, so not necessarily. Asmongold falsely accused Mizkif of threatening Emiru's employees at TwitchCon, a recent streaming event. Asmongold has enriched himself personally by advertising revenue and subscription fees garnered from his smear campaign against Mizkif. Even some of Asmongold's own viewership has noted that he was drama baiting for views. Well, yeah, I mean, people say that kind of stuff all the time. And no. But okay. This combined coordinated actions of Asmongold, OTK, Emiru, Mythic, and King have caused serious and lasting damages to Mizkif's personal reputation and business. Since the defamation occurred, Mizkif has been losing followers and subscribers on a daily basis. Mizkif anticipates the losing of existing sponsorships and increased difficulty in securing future sponsorship. It's also worth noting, by the way, because I forgot to flag the issue earlier, so I might as well, as issues pop into my head, some or all of these agreements could be specified that they have to be arbitrated rather than in a lawsuit. So if the employment agreements or ownership agreements or whatever have an arbitration clause, then that's also not going to allow those issues to be in federal court. So so you can anticipate a fight over these issues being in court at all, because it's likely some of these contracts have arbitration clauses. So, yeah. So some of that could get aggregated off for that reason. Regretfully, the extreme nature of the misconduct here has compelled Mizkif to file suit. Okay. Count one, breach of contract. Now, I will give whoever wrote this some credit, because I like this. I like this style of writing. It's clean and to the point. I appreciate that. A lot of attorneys, just want to go on in verbose ways. And I appreciate that this is just setting out the basic fact pattern. It's not like overly complicating it. It's already complicated enough, right? We just have to give notice pleading in America. So you just have to put them on notice what you're suing over. This should be sufficient for notice pleading. So it should be sufficient to get going. And it doesn't try to litigate the entire thing in the complaint. There are times for that, to be sure. But I do appreciate that this is relatively clean. So whoever wrote this, I approve. Except for the one line, you really shouldn't have wrote that. The one line where you basically said that your client was shaming Emiru for what she was wearing because it was the wrong thing to wear because she was asking for it. Other than that, you really shouldn't have wrote that line. Other than that, you're doing pretty good though. So approved. Count one, breach of contract. Plan for fully incorporates OTK breaches ownership agreement with Mizkif by purporting to oust him from ownership when no breach or default giving authority to take such action occurred. Yeah, standard stuff. OTK acknowledged it took no effort to investigate the breach, which may or may not be required, claiming in its own words that OTK is not involved in nor aware of the content of such personal matter they may have with each other, which may or may not be the reason they terminated the contract, blah, 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 blah. Nonetheless, OTK anticipatorily breached his contract. Well, no, they didn't anticipatorily breach, according to you. They just breached, right? Anticipatory breach is where they say we will breach in the future. They didn't anticipatorily breach. They just breached, according to you. right? So an anticipatory breach would be something like, I contract with you to build my house. And I believe, and the contract says something like, I'm going to pay you in phases, right? I'm going to pay you, in 3 phases based on work completion. Okay. So I've paid you for phase 1 in full, and you have not done phase 1. And then you come to me and say, okay, in 2 weeks, if you don't pay me more money, I'm not going to continue working. And then I say to you, but you haven't finished phase 1 yet. I'm not required to pay you until you finish phase 1. And you say, we think we finished phase 1. So we're going to, in 2 weeks, if you don't pay us, we're not going to keep working. So do I have to wait 2 weeks to sue you? No, I can sue you now. But that's an anticipatory breach. You have told me with certainty, like it's not contingent, it's certain that this will occur, and I don't have to wait for it to occur, so I can sue you now. That's an anticipatory breach. This is not anticipatory. According to you, they've done it already. They're not saying they will do it. They're saying they have done it. So I think that's a missed word choice. Similarly, King breached his agreement with plaintiffs by purporting to divest them of stock when no breach or event of default permitting the same had occurred. These breaches of contract have caused damage to plaintiff by purporting to divest them. Again, very, very simple, very clean. Count 2, defamation. Plaintiffs incorporate the allegations. Defendant Schnuck and Hoyt have repeatedly published untrue, defamatory statements concerning Ronaldo to an audience of millions, painting him as a rapist, domestic abuser, and emotional abuser. Broadly speaking, that has been vaguely what they have been saying, correct. These statements were made with actual malice. I mean, yeah, public figures almost certainly implicated given the scope of these people. So yes, public figure status is almost certainly correct. So fair enough. If Schmuck and Hoyt knew at the time they published, they would have been false. Well, that's potentially, yeah, that's fair, because if it's her allegations, she would know whether or not they're true. So that's fair. So she would know because she was there. Fair enough. How Hoyt would know is less clear. How Asmongold would know is less clear. So, yeah, Emiru would know if she's lying about the assaults because the assaults happened or not while she was there, not by necessity. How Asmongold would necessarily know, unless he was also there, unclear. So that part's a little underdeveloped for my taste, but okay. They knew they stood to benefit from the ouster, and associated companies, and coordinate the timing of statements to maximize injuries. These statements have caused severe damage to the reputation, business, have caused severe emotional damage and distress. Count 3, declaratory judgment. A little odd to add it as a count, but fine. An actual controversy exists with the purported controversy. Actual controversy exists. Controversy, declaratory relief. Declaratory relief is I just want you to tell me what's true. I just want you to declare the contract to be what it is. So I just want you to say what the contract is. So, fair enough. Easy. Attorney's fees. Based on the relevant law, they've been forced to retain pursuant to law. They're entitled to recovery from attorney's fees. They're further entitled to recovery fees in connection with relief sought. And they further claim entitlement to attorney's fees they may have at law. As to whether attorney's fees apply or not, there can be a fight over that later, but fair enough to plead it now. Plaintiffs have been damaged by acts and omissions. If you want to sue them for omissions, a negligence cause of action might have been warranted. Yeah. Reputational harm, loss of business goodwill, loss of earnings, loss of potential, emotional distress, and mental anguish. Not to say, of course, that he can't amend later with other causes of action, but this is enough to get started for sure. Wherein the following: we want award of damages, reasonable fees, pre and post judgment, declaring that they have no claim, declaring that they attempted to divest were ineffective as a matter of law, and granting such other relief. So this is basic, clean, submitted by Aaron Burke of burkebog.com. Burke Bog Nowitz PLLC in Dallas. Okay. Well, Aaron, first of all, I do appreciate your clean writing style. So, props to that. That's very good. Props, clean, gives you latitude for the future, gets the ball started, fair. So, well written. As for the underlying causes of action, who can say? As to the breach of contract, breach of contract is the big claim, right? Breach of contract because you stole my shares and took money from me in the tune of millions of dollars in equity interest and all kinds of stuff. So breach of contract is the big claim. In order to determine that, you have to know the contracts. Many plurals, I'm sure. There's going to be the original owner's agreement. There's going to be the bylaws of the corporation. There's going to be any number of probably other agreements that probably exist. It's probably just not the owner's agreement. Smart money says there's a couple other operative agreements that are in relating to this. So we need the agreements for starters. If I'm representing OTK or any other business entities, I want to know, obviously, every ground that we could have to breach contract or to terminate the agreement, not breach. Every ground we could have to terminate lawfully. I want to know every ground we could possibly have. And then I'm going to plead them all because of course I am. Every possible reason that we had to breach this or to terminate the contract. So I'm going to throw all those into the mix. And then, Mizkif will have to fight against all those. And I'm also going to have to deal with the issues of arbitration agreements. And whether or not we want to arbitrate is going to have to be a discussion, I assume. And if we do, we have to file dismissal on that basis, relatively promptly. And then based on, all that stuff, we'll go from there. As for defamation stuff, it's a little, the problem, I'd file a motion to dismiss basically on the defamation stuff. I'd say that, the statements are opinion, that they are, so they're non-actionable at all. They're just pure opinion for the ones that he made. And then I'm going to try to say, as for anything else, that it's based on, I'll talk to the client and go from there, but that's what I think. So, yeah, I don't see this settling anytime in the near future. So we will look forward to covering this in an ongoing fashion. And if Asmongold or Emiru or OTK need a lawyer or assistance, I'm happy to help. Because, yeah. So all that good stuff. It's on the docket as Exhibit A. Yeah, fair enough. Let's pull it from the docket. Fair enough. Let's pull Exhibit A from the docket and see if it answers any of these questions, although the answer is probably no. But let's pull the original from the docket and see what attachments there are and see if they help in any way. Give me a second to pull it up. Okay. Okay, there's a complaint. There's a cover letter. Yeah, the sale sheet. So we have the letter. We can cover the letter. The one-page letter. All of its lettership glory. It's a good place to start. Okay. Make it look pretty-ish. Great. Okay. Here we go. All right, so apparently this is the letter that OTK sent Mizkif. So we'll read this. OTK on October 24th, 2025. Second notice of termination and repurchase demand for repayment. Dear Matt, on or about November the 6th of 2023, OTK Media issued you a first notice of termination. Okay, so yeah, right away, it's like, oh, no, yeah, that's promising for OTK. Like, yeah, that's very good for OTK right away, right? Yeah, if any of that is even close to true, we fired you 2 years ago. So it couldn't have had anything to do with this because it hadn't happened yet. So yeah, that's very good for OTK right from the start. Excellent. Issued you a first notice of termination and repurchase. As described there in the first notice, which issued as a result of material breach between you, OTK, and the company. Specifically, OTK referenced your course of misconduct, including multiple instances of unwanted physical contact as a basis for decision to terminate. So 2 years ago, they were saying there was unwanted physical contact issues. Okay. As the basis for determination to terminate your engagement with OTK and exercise its right to repurchase all your shares in accordance with a promissory note and subsequently amended. Okay. OTK has now learned that you furthered your course of misconduct involving violence, threats, disparaging remarks, and blatant disregard for OTK and its company affiliates, including without limitation King Gaming Labs and Mythic Talent Management. As a result, the company must take additional actions to address your misconduct and ultimately terminate any and all relationship between you and the company. Okay. As fully set forth below, your continued pattern of misconduct and breach of owner's agreement has caused OTK, KGL, and Mythic to terminate their respective agreements with you and pursue claims against you. As recently as Saturday, October 18th, 2025, at TwitchCon in San Diego, you made threatening remarks directed at Emily Schnuck, also known as Emiru, an OTK owner, after learning she was the victim of a sexually motivated assault. The sexually motivated part is debatable, but not really relevant. During a meet and greet. Upon information and belief, your threats to Emiru were made through individuals adjacent to both OTK and Emiru's personal business, and they pertain to potential allegations against you by Emiru of an exceedingly sensitive nature. Upon learning of the potential allegations, you threatened personal and professional harm. Yeah, okay, so this makes things even more interesting too, for counterclaims from the company. Because he's an owner of the company, he has duties to the company. He has fiduciary obligations. So as OTK, one of my immediate thoughts is countersuing for breaches of fiduciary duty, right? This person is not just anybody. It's a fellow co-owner of the business. That raises a whole host of problems for Mizkif. Because as a owner of the business, he has a fiduciary obligation to the business as a whole, including its co-owners. And yeah, so the countersuit, it could be very, very real. Yeah. So yeah, that could be incredibly real. All right, where were we? And also by publishing this letter publicly, yeah, I'm seeing counterclaims against Mizkif. This could go on for, yeah. Okay. Upon learning of the personal allegations, you threatened personal and professional harm to Emiru in its efforts to silence her from publishing allegations against you. Incidentally, by the way, this could go the other way too. So, because she's an owner, and so she has, this could get really messy. While OTK is not involved in nor aware of the content of such a personal matter that you or Emiru may have with each other, OTK will not tolerate threats or misconduct by you towards members of the community. The nature of the allegations in tandem with your hostile response to them represent only the latest but some of the most egregious instances of misconduct. In addition, on all the recent occasions, you made and published disparaging remarks about OTK and his talent on social media in contravention of the terms. Yeah. Not only is it in contravention of the terms, it's a fiduciary problem, right? Even if there wasn't an agreement, he has a duty to the business because, yeah. In contravention of the terms of the owner's agreement and associated social media policy, including but not limited to the following statements. F streamers, F all of them, F everyone, F Foz Clan, F the fourth floor, F OTK, F everyone. I'm just going to start being a solo streamer. I never need anyone. They needed me. Yeah, I've decided which side of this lawsuit I want to be on. Yeah, Mizkif, you already have counsel, so I'm not interested. I'm not interested in your side of the lawsuit. I'm going to take the other side of the lawsuit on this one. See you in court, I guess. This is low. OTK failed miserably. Nobody wanted to buy it. Didn't make sense to anyone to ever purchase OTK or run and operate. So now OTK is very small. Okay. OTK has also recently learned that you committed additional willful breaches of your owner's agreement by violating the exclusivity requirements. Great. That's great. Specifically, you engaged third-party agents to perform agent services in violation of the representation agreement, resulting in you having entered into extra contractual agreements during the term with an estimated value of $4 million. Yeah, that looks like potential. Again, do I have to say this? He's an owner of the business, so he has duties to the business. If he's diverting business, away from the business to his own private enterprises and self-enriching. Yeah, this is okay. As you know, Mythic is entitled to management fee under the representation agreement for each agreement entered into the term of representation, irrespective of whether the agreement properly purported or negotiated by Mythic. As such, Mythic is entitled to more than $600,000 in management fees related to these extra contractual agreements made outside of representation. Could well be true. Yeah, basically we would have earned, I think they're saying we would have earned these fees. And because you didn't give us the clients, you diverted them from us, so pay us the fees we would have been owed. Yeah, that makes sense. Yeah, that could work as a cause of action. Yeah. In addition, Mythic is entitled to 5% interest per year on overdue management fees plus costs and attorney's fees associated with the representation. In a manner consistent with your prior misconduct, the allegations, threats, disparaging remarks, and willful breach of representation, together the misconduct, clearly tend to injure the success of OTK and its affiliates, pose a future liability to OTK, and publicly bring OTK into disrepute in addition to being offensive, vulgar, scandalous, and defamatory. Not only does this misconduct constitute the latest example of your habitual breach, including but not limited to a whole bunch of stuff, but it sends a clear message that you do not value your relationship with the company, nor are you aligned. Well, yeah, I picked up on that long ago. I picked up long ago that he is not aligned with the company. Yeah, yeah. At the time of the first notice, the company elected not to exercise its termination and repurchase rights, although it explicitly reserved the right to do so in the event of a future breach. So basically, we gave you a warning already. Basically, we said we could fire you, but we're not going to. In light of the foregoing, please be advised the majority of the board of directors have elected to terminate the owner's agreement on behalf of KGL and repurchase the entirety of your shares in accordance with the ownership term. Well, if by repurchase they mean they're going to give him fair value for the term, fair value for it, then that's probably fine. Yeah, the way Mizkif told the story, they're just going to seize it without paying. If they're giving him fair value for the shares, that's probably fine. And now how we calculate fair value is a whole other set of problems, but because you're not dealing with a publicly traded company, so trying to calculate fair value can be tricky. But if they're paying him for his shares, then yeah, they're just buying him out. So fair enough. Okay. Effective immediately, you'll no longer render services to KGL, nor will you be affiliated with the company in any way. Pursuant to T-Do, please immediately remove any references and company IP from your social media. As were the circumstances of OTK's previous repurchase, all shares of stock held by you will be repurchased by such terms and set forth on the promissory note attached. Oh, okay, fair enough. So, like, if they have an agreement for how they'll be repurchased, then that's great, right? This is a good functioning company, right? It's like, yes, this is exactly how we're doing it, and we're doing it by a promissory note. We will pay you in the future. If that's what they agreed to, then fine. So they're giving them exactly what they promised contractually. Fine. Yeah, that's all good. No problem there. Attached here too as Exhibit A. This is Exhibit A now to the letter. Notwithstanding your separation from OTK and KGL, all their existing agreements that you have with the company will not terminate and remain full force and effect, including without whatever surviving sections of blah, 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 blah. So basically, even though we're firing you, you're still bound by the contract because, of course, you are. Right. Furthermore, the aforementioned misconduct and your continued complete and utter disregard from the provisions have now given rise to rates and obligations under the note. As a preliminary matter, please accept this letter as notice that OTK has hereby elected to purchase the remainder of your shares pursuant to the note. In addition, please be advised that OTK, through a determination of its board, has voted to exercise its right to terminate and cancel a promissory note. Okay, so apparently now they're going to not pay him anymore. So we were going to pay you, but now we're going to cancel the note. So that's, now we're back to they just want the shares without paying for it, which maybe they can do, maybe they can't do. It's all contractual. So, yeah. Accordingly, the shares that were eligible for repayment are hereby vested as property of OTK without any further payment. So we're just taking it and not giving you any money. Moreover, as a result of disparaging remarks and continued breach, the promissory note dictates you must refund all amounts remitted to you in connection. Therefore, in addition to the $600,000 we talked about earlier, we also want another $300,000 to remit not later by November 1st, and not so much. In the event you fail to do so, the company will use every legal remedy, blah, 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 blah. The terms of this letter are confidential information and are protected from disclosure. As such, you will not disclose, publish, or otherwise communicate the terms of this letter. You must cease and desist from publishing any public messaging in connection with your relationship. An actual breach should be met with swift action. No ways company provide you with legal advice. Company reserves all right. If you should have questions, blah, 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 blah. Yeah, all right. So yeah, we're in it. We're in it for a fight, guys. We're in it for a fight. This could get very interesting and very dramatic. And we're going to have issues relating to this lawsuit being in Texas versus Delaware. Some of these actions seem like derivative corporate actions. So some of this stuff really probably belongs in Delaware. So we're going to have a fight over that probably. We're also going to have a fight over whether or not there are arbitration agreements. So there's that. And also whether or not these are counterclaims to an existing lawsuit and should be merged into an existing issue or whatever. So this is going to get interesting in a lot of different directions. This could get squirrely. And I don't imagine any resolution anywhere in sight. If we're going to have a fight over arbitration versus Delaware versus Texas, that fight alone could go on for, a year plus. So I hope everyone's real comfortable, because this could take a really hot minute. Exciting. OTK is incorporated in Texas. Is it? Well, some of this stuff was incorporated in Delaware. Hold on. No, OTK is incorporated in Delaware. OTK is Delaware with its principal place of business in Texas. Mythic is Delaware. King is Delaware. Yeah, it's all Delaware. It's Delaware through and through. This is one of those 3 to 5 year cases. Yeah, could well be. Could well be in multiple different jurisdictions. Yeah. And the defamation case alone, you're looking at 6 figures, probably, between everything that happens. And then you're in a fight. this entire cause of action, depending on how squirrely this gets and in what jurisdictions this gets to, this could easily be a 7-figure cause of action. I mean, in terms of attorney's costs, 7 figures. This could well be 7 figures, depending on how squirrely this gets. So you're looking at something between, I don't even know. You're looking at something between, how about a range of 500,000 to 5 million as a reasonable working estimate. This, especially if we're dealing with appeals, reversals, it could get, that's. So let's respond to some comments, see what you guys have to say about all this. On the plus side, if I don't become an attorney in this case, I have content for a while, so I got that going for me. So that's nice. Asmon is way more rich than the other two. He may be way more rich than the other two, but they both have sufficient FU money, is my only point. They all have sufficient FU money. So, yeah. The ownership thing sounds a lot more interesting. The ownership thing is a lot more interesting legally. It's a lot more interesting and a lot more complex. Yeah, so the ownership and the recovery of the shares, the buying back of the shares, and then the not so much with the buying back part, that's going to be a much more factually interlaced pattern. That's going to be a lot more factually detailed because you're looking at multiple different corporate agreements with multiple different contracts, I'm quite sure. Interlay of multiple different things. It's going to be a thing. Why would you sue for breach of contract and defamation the same cause of action? That is a good point. Like you can, it's just a little weird. I mean, you can bring all causes of action you have, but they're very disparate. So I could very easily see a judge segregating this out. I could very easily see a motion to sever, a grant of sever, because they're just too interspersed. It is weird to bring them in one common action. So yeah, a motion to split this apart could be in our future. Yeah, there's a lot more co-owners, I'm sure. Mizkif admitted in his video that everything he said was true. Well, as to what they did or did not admit, you can better believe there's going to be, as to what they did or did not admit in what videos they said, you can better believe there's going to be a whole bunch going back and forth. She threw a plushie at him. She's going down. Mizkif took out of context what Asmon said. Of course he took it out of context, but that's to be expected, right? In lawsuits are allegation and shade. You would expect Mizkif to try to put the facts in the most favorable light to him. You wouldn't expect him to do anything else. Of course, everything in this lawsuit is shaded as best Mizkif can make it. Why wouldn't you? Yeah, tell me something else I don't know, right? You want to know the art standing behind me? This piece of art? This is Freedom of Speech by Norman Rockwell. This one over here is also Norman Rockwell. This is, I always forget the name of this piece. This is, I think, called The Trouble We All Live With. This is depicting Ruby, I believe was the name of the girl. This is depicting Ruby as she was being integrated by the federal marshals in New Orleans. And so, yeah, they're both Norman Rockwell. Asmon said before, spent a lot of money hiring people to look into things last time this was accused. Yeah, I have no doubt. Yeah, so any prior reports, prior things, yeah, I'm sure the company has, and that's all going to be in discovery. The discovery is going to be real. It's going to be extremely real. The discovery alone is going to be, yeah, just doing discovery. Well, discovery, to be fair, is a lot where costs incur. So me saying the discovery alone is going to be expensive is Me just stating the obvious. Your money's on the fact that when they broke up, Emiru wanted out of the company in revenge? Could be. Asmongold has a last name? Apparently. Some of it happened on stream. Again, this will all be as to what is or is not on stream, what she did or did not say, allegation, all this will be, yeah. If I'm yeah. Yeah, DMs, the text messages, it's all going to be a thing. Why would you include it in the primary complaint, the exhibit? Why would you include it? To embarrass them, to embarrass the other side. I mean, there's no particular reason to do it. There's no particular legal reason to do it. It's like they know what the letter is. You don't need to give them a copy. They wrote it. So like, there's no particular legal reason to do it, just to embarrass the other side. Not to say that isn't a valid motive, by the way. You can definitely do things just to embarrass the other side. That's definitely a valid thing to do, but that's the reason you did it. Miz's Twitter's restricted? I'm sure. Asmongold does not stream under the name Asmongold. He uses the name Zakar. Okay, fair enough. Either one. I think he uses both. Because either way. Oh, you mean his actual streaming name as opposed to like other names he uses for like video on demand? Okay, fair enough. Yeah, fair enough. I'm going to call him Asmongold if it's all the same. If he hires me, I'll call him anything he wants. Since he's in California, unlikely to have anything to do with it, but could be fun. This is 3-year lawsuit. You wish. Yeah, good. Yeah, 3 to 5 years. Do the defamatory statements specify in the complaint? Kind of. He kind of alludes to them. He does put enough notice in there. Yeah, that's in there, sort of. Should any of them take the stand? That's a long distance in the future. As to who will take the stand, that is, you are asking a question that is 4 years away, man. Should I take the stand? I don't know. Ask me in 3 years. You know what I mean? Who knows? We're going to have to do depositions first, and depositions aren't going to happen for 1.5 years if we're lucky. Maybe that's a little over exaggerated, but you understand my point. Yeah. Settle by the end of the year? I don't see a settlement happening. There's a lot of money at stake here. There's a lot of money. I mean, to be fair, sometimes big money things happen, but we're talking multiple millions of dollars that are involved in this thing. And everyone has money to burn. So, and also Asmongold, I think, has offered to pay legal fees for other people too, because he's so rich. So Asmongold is not only going to burn his own money, he's going to burn, I think he offered to pay legal fees for Emiru. Not that she doesn't have her own money, because he has got so much money to burn. So, yeah, all that good stuff. All right, well, we'll keep following this lawsuit for sure, because there's a lot of intrigue. I'm interested in the corporate stuff, because that's very intriguing. With the corporate stuff is fun. The defamation is just, a run-of-the-mill defamation case. The corporate stuff is fun. Yeah, Asmongold would never settle. He roach out for the love of the game. Yeah, that seems likely. Asmongold has no particular reason to settle either, because he will cover it. He will. Normally, as his lawyer, I'd tell him not to talk about it. In this particular situation, I'd strongly consider, just talk about it. Fuck it. Not that he wouldn't do it anyway, but, I'll tell him not to talk about certain things, but he'll make enough revenue from talking about it to pay my fees. He can just pay me by talking about it. So it works out well for me. And then of course I get to cover it as the attorney. So not only do I get paid, I also get to talk about it and get some pay that way. So we all get rich. It's great. And then Mizkif gets sad. And then, hopefully in the end dream, of course, the end dream, of course, is I want a writ of attachment and I want to go into his house and I want to take away his hand towels just because I can. It's that really petty thing in me. It's like, of all the things I want, it's like, I want to go in and take your hand towels just because I can, because that's the level of petty I am. Like, that's what I'm suing for. Yeah. Good times. Yeah. All right. I'm going to go ahead and sign off. This lawsuit is interesting, involves a lot of interesting interplay. You're thinking counterclaims out the ass. All kinds of counterclaims. You're thinking arbitration. You're thinking all kinds of stuff. Yeah. And we will talk more about it. Look forward to it. I've been Uncivil Law. Until later, my friends. I hope all is well. Cheers for now, my friends, and goodbye.